The United States Court of Appeals for the Ninth Circuit is now in session. Please be seated.
Okay, good morning, everyone. Welcome. Welcome to the Pasadena Courthouse. We are going to hear argument today in two consolidated cases, City of Portland versus the United States and Sprint Corporation versus the FCC. As the parties know, we have divided that argument into two segments based on the subject matters of the petition for review. The first argument will address the petitions for review of the moratorium and the small cell orders, which are at issue in both the City of Portland and the Sprint cases. And the second argument will be the petitions for review of the regulations announced in what the parties have referred to as the utility pole attachment order. We're going to have 40 minutes per side on the first case, 15 minutes on the second. The parties have helpfully indicated the amount of time they need and how they have divided it, and the court has agreed to that. Petitioners in the first case will have time for rebuttal, same in the second, and it's your job to maintain the clock and to reserve your time. So without further ado, we'll hear argument in the petitions on the moratorium and the small cell order. And Mr. Van Eaton, you may proceed.
May it please the court. I will address the general objections of local government petitioners to the moratorium and small cell orders. My co-counsel will address, respectively, the public power objections to the order and the RF objections to the order. So let me begin by calling your attention to the streetlights owned by the city in the right-of-way just outside this courthouse. They're very decorative poles with a little bulb on top. I'm sure you've seen them many times. Under the order as issued by the FCC, if a carrier told the city, we want to replace that light and put in something that's a small cell, meaning it could be up to 50 feet high and it could have a 28 cubic foot attachment to it, the city would not be able to say, we don't allow attachments on these poles. That would violate the moratorium order. It would have to accept the application, and then it would have to begin to apply the FCC's rules. It couldn't ask the carrier, can you go somewhere else? It wouldn't have to investigate alternatives, and it wouldn't even have to show that it actually needs the facility.
Maybe I misunderstood what you said. Was the request of to replace the pole or to add an attachment to it?
To replace the pole. The FCC order functions exactly the same either way. In fact, in most cases, the record from Howard County showed, I think it's LGER 703, you almost always have to replace light poles because they aren't designed to hold small cells. So the effect is to actually require the replacement of the pole with something new up to 35 feet, and you can't say, could you look at the parking lot across the street where the U.S. government has very large street lights of a very different design, or can you look at putting it on the building, this courthouse or the Shakespeare Club right next door. You wouldn't be able to, those are not germane to considering whether they're entitled to take out the city pole and replace it with something else. The city's going to have to respond, and at the end of the day, if that street light is replaced, it gets a total of $270 per year unless it agrees to, unless it conducts a cost study. And in the cost study, you're only going to be able to think about things, the FCC order suggests you get to think about things like maintenance cost. But the cost in terms of lost property values along the street, and the city does own several, as you're sure you're aware, it owns a lot of the properties on the street, that would be lost forever. If you move down the road to the to where the Rose Bowl parade is going, Pasadena every year has a moratorium that applies to all construction on the Rose Bowl parade route and the surrounding streets that runs from basically November to January for the obvious reason that they have to build the grandstands to handle between 700,000 and 1.8 million people coming in. Under the FCC order, because that is an express statement you can't build during that time, that is an express prohibition. It's under the FCC rule for moratorium, it's deemed to prohibit, and the city would essentially have to accept and approve applications for construction during that time period. It wouldn't have a basis because the FCC also says this has refusing to take permits or process permits for that period. You can't defend that as a reasonable management of the rights of way. Now, ultimately, the scenarios I've laid out for you are things we think can't be squared with the plain language of the law, which is intended to preserve local authority over the placement of wireless facilities with certain exceptions.
So what was the FCC's response when you made these points during the administrative process?
So during the administrative process, we did raise the issues about streetlights and the problems of streetlights. Howard County raised them very specifically. And basically, we think they never really considered those issues. During the moratorium proceeding, we kept saying, we've raised arguments about the moratorium and said you can't possibly mean to reach things like this, but your definition is overly broad. We raised that in connection with Myrtle Beach, South Carolina, which submitted material saying, look, we close down roads we don't allow construction during hurricane season on the roads because if we need to get people out, we can't afford to have the roads torn up. And the FCC said, no, it's a prohibition, that's it. And I suggest they made 4 basic errors.
Well, some of the points you're making, I mean, this is essentially a facial challenge. Some of the points you're making might end up having some merit in a as-applied challenge with respect to a particular jurisdiction.
Well, with all due respect, we may be able to raise it, but as you know, the FCC and many people actually contend that the Hobbs Act requires us to raise our issues now. And the question is whether they've defined the standards well enough to distinguish between things that are permissible and things that aren't permissible. And I don't think they have. I don't think they've done that for purposes of effective prohibition. I don't think they've done that for purposes of aesthetics, and they certainly haven't done it for purposes of moratorium. So for this order to be valid as a rule of law, and that's the idea, this is supposed to have the force of law, it needs to be clearly defined. It needs to have limiting standards. That's the Iowa Utilities case involving AT&T. And this case really doesn't have limiting facilities. It has too many cases that fall off that basically make no sense. And I think that's because it made 4 basic flaws. The first flaw is I think it applied the wrong definition of effective prohibition. This circuit en banc has ruled that the plain language requires that to be a violation of either 253A or 332C7. The action must actually have the effect of prohibiting or must directly prohibit, that is, facially prohibit. The FCC didn't apply an actual prohibition standard in adopting these rules. And you can actually see that pretty clearly in the aesthetics discussion, where the FCC basically says, look, if they have to learn all the local rules, and the local rules, even if they're fine for everybody else lives under the zoning rules, if those standards might be confusing to these folks, that imposes cost, therefore they're prohibited. But their own case, California Payphone, and of course your Ninth Circuit case, don't allow mere cost to rise to the level of prohibition. The same thing with the moratorium. The FCC never considers whether someone can plan around the Rose Bowl parade, which of course they can. They simply assume that any delay in any way reflecting the permitting process is going to be a prohibition. So we think that failure, the failure to apply the standard that this court adopted en banc based on plain language, requires that the decision be vacated and sent back to the commission for determination to see whether it would come to similar conclusions if it applied the correct standard.
Go ahead.
Okay.
Well, your position is that our decision in Sprint precludes the application of a materially impede standard.
Obviously, once you move away from the word prohibition, which has a pretty well-defined dictionary meaning, I think, once you move away from that to use sort of synonyms, you can get into a very confusing question about whether they're actually looking at actual prohibitions or not. In the California Payphone case, they said, what we mean by materially inhibit isn't cost or increase, we mean that it makes the service non-viable. In the current case, that's not what they're saying. They literally define materially inhibit, meaning we prevent the operator from putting in the facilities of the type it wants, with the functional characteristics it wants, in the time it wants. So essentially, we're prohibiting if we put a burden on the operator doing what it wants. And that can't possibly be squared with the intent of the law, which every court has recognized is intended to preserve zoning authority and allow us to say no sometimes. And zoning, for not just these folks, but for everyone, often results in folks having to change their plans, maybe design things differently, maybe do it at a different location. It always involves, by definition, some inconvenience because of the process you go through. So we don't think Congress could have intended or would have thought, if they were letting zoning apply, that they were intending to prevent communities from saying no, or preventing them from saying you can't go in certain places because of the character of the neighborhood, unless you can really show that there is a prohibition on the service. And that, I think, the FCC hasn't tried to do. The same thing is true with the fees above cost. They basically assume that if fees are in excess of cost, that will result in a prohibition. And that
Council, what's the mechanism for challenging that? So if a city thinks that they've got costs above the 270 annual limit, what's the mechanism for the city to do that? Where do they bring the action?
So well, that's a good question, because because I presume what would have to happen is the city would have to deny for a failure to pay costs that they impose. And then when you went to court, the way the decision works is it assumes that if it's above cost, it's a prohibition. And then the locality has to show that its cost actually exceeds the amount.
How does the city get into court? So if the city of Los Angeles said, look, it's really $400 per poll per year, not 270, that's worth litigating over, where does the city go? They go to the FCC, or they have to go into federal court?
So I think they could go to, I think they would have to go to court, because 253D doesn't allow the FCC to decide what right-of-way fee should be.
What's the cause of action?
Well, it's a good question, because we don't have a cause of action. Whether the city can get an interim relief to get a sort of a declaratory ruling.
A declaratory ruling on what?
That's my problem. I don't see until there's an actual application pending under the FCC shot clock. There's nothing.
Your understanding is the FCC is not contemplating that these cost questions will come to the FCC.
I think the FCC contemplates that a carrier could come to them and ask them to decide this under 253D, and the court, the structure of Section 253 seems to suggest that a supremacy clause type claim could be brought in court by the provider under 253D, arguing that the city's fees that it's refusing to pay are prohibitory and not saved by 253C or 332.
So let's suppose, can the carriers agree with the city that the city's costs are above the presumptive level, the safe harbor, the 270?
Well, that's a good question, because the FCC basically is declaring that fees above cost are prohibitory. So I'm not sure that they can.
But let's suppose that the city of Los Angeles said to the major carriers, Verizon, AT&T, T-Mobile, and Sprint, our costs are really $400. We'll open the books and show you. And they said, no, that's okay. We'll negotiate with you. Can they agree that it's going to be $400?
They should be able to agree. The FCC's order calls that into question because, as you know from the record, there are hundreds of these contracts in place.
So the FCC's theory is that the reason that we're not going to allow costs above a certain level, and anything above costs is prohibited and preempted, is because the theory is that the carriers could then take that money and invest in rural areas, other cities, and so forth. So if the city of Los Angeles agrees to $400, and the carriers or the city says it's $400 is our cost, and the carriers all agree because they're very anxious to get into Los Angeles immediately, and the city of Fresno comes and says, we don't think it's above $300, does the city of Fresno have the right to bring an action because these carriers are being slow to develop 5G in Fresno?
No, in fact, that's one of the flaws with the basic flaw in this whole cross-subsidy argument, because that's what this really is that carriers will take money saved in Los Angeles and invest it in an area that's not now profitable, right? there's no economic theory that supports that idea. The whole Universal Service Fund is based on the idea that a rational investor will make money where they can make money, and then they don't take good money and pour it into an area where it's not profitable out of the goodness of their hearts. That's why we actually have evidence where Lincoln, Nebraska dropped the fee to $95 and said, all you have to do is build out these less profitable areas, and they got no takers. There's no evidence that cross-subsidy actually results in the effects the FCC has, and certainly the FCC doesn't require it, and it doesn't give anyone any enforceable right to say, if you're saving money in LA, you've got to come to our community.
One of the FCC's arguments is that they can aggregate the fees above costs. Are you taking issue with the aggregation mechanism, or are you agreeing that aggregation is permissible and just in this case it doesn't work?
I take issue with the authority of the commission to do an aggregation at all, but I also think the aggregation method was flawed.
So what's your basis for that first point?
So the reason the first point is the structure of the act is to preserve local zoning authority. And it's really easy to see, and by the way, I just want to emphasize, 332 is the only provision that applies to decisions regarding the placement of wireless facilities. The FCC made an error in saying otherwise. But under 332C, right, it's pretty clear that what Congress was contemplating was a localized determination on a case-by-case basis of placement of facilities. And I think it's hard to imagine that in that context, Congress would have intended effective prohibition to not be equally focused on the local impacts as opposed to a assumed national impact. And I also think it's very hard to say that if Los Angeles does X, it's going to in fact have a butterfly effect that's not just possible as opposed to actual. And you can see that in our brief when we talk about the fact that in fact where the money is going is in stock buybacks and things like that. So I don't think it's intended, given the structure of localism and local decision-making, to allow those aggregate effects to be considered except in exceptional circumstances. The Guayanilla case was a good one.
It's not irrational for the commission to say, look, if we just open this up to competition, just let LA charge whatever the market will bear, because LA is a big community, they clearly will pay more there, and therefore clearly they will not have money to invest someplace else. Now that doesn't tell us that if they have the money they will invest it. They might just up their profits. They might do something different. But it's not irrational to think that if LA is charging $1,000 per pole, that there isn't money to go to Fresno.
Well, it actually is a little bit irrational in this sense. One of the reasons New York people will pay more to be in New York or in Los Angeles is because they can make more money. You can't just look at cost divorced from revenues. That's a basic economic principle. And if what's happening is the carrier is actually earning a reasonable return in Los Angeles, it shouldn't affect their ability to go into any other market that's also a viable market. The idea that you spend more, and the idea that in a competitive market, if you spend more to go to a place that's more valuable to you, it somehow prevents you from going somewhere else, seems to me a little bit of a stretch.
You're saying that you don't agree with their economic theory. Can we say that?
I think you can, because even when we're dealing with, and this is something like a predictive judgment, even when predictive judgments are given, particularly on economic issues, and particularly if under your interpretation that an actual prohibition is required, I think the case law would suggest there has to be sound economic theory supporting what's done, and I don't think there is. I would like to reserve the remainder of my time if I could, unless the panel has any additional questions they'd like to ask at this point.
Thank you.
Thank you.
May it please the Court, Sean Stokes on behalf of Petitioner American Public Power Association. With the Court's permission, I'd like to address the FCC's improper assertion of regulatory authority over attachments owned by public power utilities, that is, government-owned electric utilities, despite Congress's express withholding of such authority in Section 224 of the Communications Act. Now, it's axiomatic that the FCC only has that authority that's granted to it under the Communications Act. And the only grant of authority over electric utility poles in the Communications Act is found in Section 224. And Section 224 explicitly denies the FCC's authority with respect to public power utility poles. Now, it's helpful to very briefly go through the history of how this came about. In 1997, when cable was the nascent industry, the FCC looked hard to see whether it had authority to regulate attachments to electric utility poles, and it found it did not have such authority. In 1978, in response to that, Congress enacted Section 224 of the Act. Section 224 grants the FCC authority to regulate rates, terms, and conditions by cable companies at that time to electric utility poles. Importantly, however, the FCC was explicitly denied authority with respect to public power utilities and electric co-ops. In 1996, as part of the Telecommunications Act, Congress amended Section 224 to expand the scope of it to telecommunications carriers as well as cable operators, and it also provided for access to such poles. Importantly, however, despite that expansion, Congress maintained and preserved the withholding of authority for electric co-ops and public power utilities. Significantly, at the very same time as Congress enacted those amendments to Section 224, it also adopted Section 253 of the Act, as well as the amendment to Section 332C7, neither of which address access to local government facilities. Now, in the 20 years plus that Section 253 has been in place, the FCC has never once suggested that it has authority over public power utility facilities. In fact, it specifically has bridled at its lack of authority. In the record, we point out in the National Broadband Plan that the FCC bemoaned the fact that it did not have authority over all poles in the country, and it specifically requested that Congress amend Section 224 in order to, in its words, develop a uniform regulatory regime to give it power over all poles. So now what we have is in an abrupt regulatory U-turn, the FCC has held that it does actually have such authority, and it's been laying hidden and dormant in Section 253 for the last quarter of the century. In a single footnote, the FCC brushes aside arguments made about Section 224 without elaboration and also no meaningful statutory analysis. Specifically, they argue that Section 253 is an independent source of authority with respect to the very same poles that Section 224 expressly prohibits them from regulating.
But why isn't it a separate source of authority?
Why is 253 not a separate
Correct.
source of authority? Well, for two reasons. One, given the fact that 253 on its face only addresses government entities acting in a regulatory capacity and deals with state laws and regulations and legal requirements that are imposed in a regulatory capacity, and it doesn't in any way address access to facilities, it seems odd that the very same law that does not speak with respect to public power utilities or indeed any government facilities would be presumed to give them this authority when Section 224 in the very same title of that act, which is also amended at the very same time, would deny the FCC authority over such
The
poles.
provision of 224 that you're focused on is C1 or
The definition.
It actually, it's found in the, Your Honor, it's actually found in the definition. Basically, it defines utilities as not including utilities owned by government entities.
Okay, so but that just applies to the term where the term utility appears. So if I look at C1, this is actually an actual prohibition on what the commission can do, and says the commission does not have jurisdiction with respect to rates, terms, and conditions with respect to poles for pole attachments in any case where such matters are regulated by the state. That suggests that the FCC might have jurisdiction to regulate such things if the state is not regulating itself. Am I misreading that?
I believe what that is saying, Your Honor, is that the assumption is that the FCC has regulatory authority over utilities for governing attachments, and the section that you're talking about is a carve-out that, well, it's actually an ability for states to opt out of the FCC's pole attachment authority by reverse preempting and saying we actually regulate electric utilities of this type on our own. For example, California has done so. The California Public Utility Commission regulates private investor-owned electric utilities, and therefore the FCC's Section 224 pole attachment authority does not apply to them. What I'm saying is with respect to electric co-ops and public power utilities, meaning government-owned utilities, Congress wrote it so that that section doesn't apply at all. In fact, it specifically says that they are not the type of utility that is even subject to any FCC pole attachment authority,
But
irrespective.
The word utility doesn't appear in 253.
Correct. I would absolutely agree with that. It doesn't say anything about facilities or utilities at all.
So how do you get the 224 restriction on 253 if the word utility doesn't appear in 253?
What I would say is that under canons of statutory construction, the specific controls the general, and Section 253 is certainly only a general statement of authority to the FCC, and Section 224 is a specific prohibition.
Isn't it more that they're just different? It's not specific general, it's just two different types of regulation, two different types of statutes.
Well, I would say there are two different types of statutes also in the sense that Section 253 is clearly aimed at when a governmental entity, state or local, is acting to somehow impede through regulatory activities. And that gets to the second point of what the Commission did, irrespective of what Section 224 says, is that the FCC misapplied the market participant doctrine, which this court has found to be applicable to Section 253 and is generally found to be applicable. The market participant doctrine under Boston Harbor and its progeny is that the presumption is that when a state and local government entity is, unless the statute says otherwise, they are presumed to have the ability to act in a proprietary capacity as long as such conduct is analogous to the way that other private entities would act in that case. And we would argue that's exactly what, at least with respect to electric utilities, how they own and operate their public, their utility poles. The FCC has flipped that, and in fact, what they've said is that that they find that a government activity is not protected unless the statute, quote, carves out an exception for proprietary activities. That's simply not what the Boston Harbor market participant test says. I see that I'm about at 2 minutes, and I'd like to reserve time. So if there's no further questions.
Thank you.
Thank you.
May it please the court. I'm Eric Godding, and I'm going to be discussing the radio frequency, or RF, issue, and I'd like to reserve 1 minute. Montgomery County's concern is what the FCC has yet to say. In response to rulemaking comments that the FCC's RF exposure standards may not reflect the current safety research or account for this new 5G environment that we're going to see in the coming years, and that the FCC must resolve those issues before accelerating the siting and the operation of these 5G small cells on public rights-of-way, the FCC offered a single sentence. It said it disagreed with any concerns that Montgomery County or others have.
I guess the issue which has been raised in the 28J letters is mootness, given the completion of this rulemaking, which had begun much earlier. So why don't you address that?
So the burden in this court is heavy on the FCC. It has to show that there's no possible way for this court to give any relief. And so in our case, we're asking the FCC to explain in the context of this order why RF is either irrelevant or why it thinks it's important and how it's going to resolve this issue.
Why shouldn't you now? I mean, your complaint originally in the briefs was that the FCC should have completed this rulemaking.
Yes.
During the pendency of this appeal. They have now done that, and so why would you not raise any challenges you have to that rulemaking in a separate petition?
I would disagree that they have done that. They've done two things in those 6 pages where they close out the NOI. They talk about cell phones, which are not small cells, and then they have some conclusory statements that the record doesn't show that they need to update these RF standards. But nowhere in those 6 pages, do they ever discuss the 5G environment? They don't discuss densification. They don't discuss the use of millimeter waves.
Yep, that may be, but why wouldn't the appropriate process here be for Montgomery County to now challenge that other rulemaking? Because the thrust of the argument initially was they just haven't completed the rulemaking, but now they've completed it. So why wouldn't you may have good arguments against that rulemaking, but how do we dispose of them in this case?
Because we didn't get the relief. If we have to go back to court and take another year to litigate this, we're not getting the relief that we want, because it's our position that they actually haven't addressed the issue. Montgomery County wants to be able to tell its citizens it's putting these 5G small cells on its property. And the citizens are asking, is this safe? Or can we walk on our sidewalks? And if we have to go back and litigate for another year, that's a year that the carriers and the FCC is allowing these to be deployed. And so we have the evidence in the record showing that these may be dangerous, maybe they're not. But we don't have the answer to that question. And I think is...
We don't have the later action before us.
But they've raised the mootness issue, so I think the court now has the obligation to decide it. So, but I think on its face, I don't think the court has to do a lot of work.
Review the merits.
No, you don't have to.
To me, you're really disagreeing with the merits of that.
No, we're not disagreeing with the merits. I think on its face, they didn't address this issue. I don't think the court needs to dig into the record or anything. I think on its face, it literally decided not to address the issue that we asked, which was to clarify, is this a potential risk or isn't it? And so we can go back to our citizens and we can take whatever steps we need to take to deal with these new small cells. And so I think in the context, I think our case is rather simple. It's kind of an APA case. In this order, our order, not the one we were just talking about, they don't explain their decision. They had a single sentence. Despite the fact that you have this huge record of concern, of studies, of research.
So, counsel, in the other matter, the matter that's closed, is that subject to appeal? Have you taken a notice of appeal on that one?
Yes.
Being arbitrary and capricious? Is that pending, and where is that pending?
So there are 2 cases, one here in the 9th that I know of, one here in the 9th and one in the DC Circuit.
Are they going to be consolidated?
Yes, I think under 2112, yes, they'd be consolidated.
You know where they're going to be consolidated?
I think DC won the race to the courthouse.
And when are those going to be heard?
We don't know yet. They were just filed. So I see I have 1 more minute left, and I'd like to reserve that for any rebuttal.
Thank you.
Yeah.
Good morning, Your Honors, and may it please the Court. I'm Scott Novak for the FCC in the United States, and I'll be addressing the main effective prohibition issues, and especially how that language applies to moratoria, fees, and aesthetic requirements. My colleague, Ms. Citrin, will then address the remaining issues. At the outset, I think it's important to set down a marker here, which is that I don't think that Mr. Van Eaton has accurately represented the orders on review here today in any number of respects. The parade of horribles that were raised on the earlier arguments won't happen under these orders, or at least there's no reason to think those parade of horribles will happen on a facial challenge here. The orders here address each issue in a flexible manner with a number of guardrails and mechanisms that are capable of addressing all of the alleged harms here on a case-by-case basis.
Since we're in Pasadena, and you've referred to the parade of horribles, let me ask you specifically about the example of the Pasadena Rose Parade and the moratorium.
Yes. So the moratoria order here doesn't say, and I think this was not represented accurately in the briefs either, it doesn't say that all moratoria are necessarily preempted. What the moratoria order says is that moratoria violate Section 253A, and that makes them potentially subject to preemption, but it then says that moratoria will be saved from preemption and will be allowed if they meet the terms Congress set forth in Sections 253B or 253C. So specifically with respect to that Rose Bowl parade question, the order says in paragraphs 160 that under Section 253C, rights-of-way management, which would be saved from preemption, may include issues such as coordinating construction schedules. And as I understand that hypothetical, if there's other construction that needs to take place along the parade route, then I think the terms would likely be satisfied there, that a moratoria on wireless construction to facilitate that other construction would apply. And there was also the issue raised of hurricanes, for example. So Section 253B says that localities are authorized to take these steps if they're necessary to protect the public safety and welfare. And we explained in the order that will address situations like natural disasters. And with respect to, I think, the opening issue here about some of, for instance, the poles outside of the courthouse, so the moratoria order doesn't purport to preclude localities from addressing reasonable aesthetic requirements. In fact, we say in the small cell order that aesthetic requirements are permitted, and we don't limit the subject of them. We simply impose some modest procedural constraints. So these poles, if the poles aren't capable of supporting a small cell, then it may be the poles need to be replaced, but a locality could require the poles to be replaced with a pole that's similar in character to the existing pole or the surrounding neighborhood. I think it could say that if a new pole needs to go up, that in a downtown area, if a 50-foot pole would be out of character with the surrounding neighborhood, you can't put up a 50-foot pole.
I thought that the aesthetic objection, the objection to the aesthetic regulation was that it was objective.
Well,
And if you've imposed a requirement that there be objective criterion, then how do you get one that's blends in with the neighborhood?
so I think the petitioners are taking the word objective out of context. I think it's clear from this order that when the commission used the word objective, it meant objectively ascertainable. It meant not unduly vague. If you take a look at footnote 246 of the order, it points out that many state small cell bills that this order was modeled after use objective for this. Now, the order specifically...
Sorry, which footnote?
Oh, sorry, it's footnote 246.
46, okay.
Points to many different state small cell bills that impose this identical requirement, and there's been no indication the sky is falling in those states. But the order specifically says that you can require, and this is paragraph 87, that aesthetic restrictions can be directed to avoiding or remedying the intangible public harm of unsightly or out-of-character deployments. So the order specifically says those requirements can be imposed.
I guess the petitioner's objection to this, I think, is that there may be an acknowledgement that certain aesthetic requirements effectively prohibit, but the effect of the order is to have a fairly dramatic influence against cities and towns all over the circuit, all over the country, really, and what they may be able to do in very unique, localized settings. And so maybe you can address that.
Sure. So let me take that first with respect to aesthetics, and then if we want to examine the other issues, I'm happy to do so. So with respect to aesthetics, I think what the order did here was very modest. It didn't stop localities from regulating aesthetics. It didn't tell them what aesthetic requirements they can or can't have. Localities are still free to adopt and craft their own substantive aesthetic requirements. All the order does is recognize some modest procedural constraints. It says that whatever aesthetic requirements a locality adopts, they must be technically feasible, non-discriminatory, and disclosed in advance. And those are very modest requirements, but they are very important. Because the record here shows...
For those three requirements, how does that function affect? Is a city preempted from issuing any aesthetic requirements unless it does that in advance?
So, Your Honor, let me first say, directed to one of your earlier questions, that these orders are not self-enforcing. They contemplate the need in many circumstances for further case-by-case adjudication. Okay. And in those instances, either someone have to come back to the commission or go into court.
Okay, so let's talk about the first one. So how
Yes.
do you get it before the commission? I'm going to have these questions with respect to costs in just a minute. But.
Yes. So Section 253D specifically authorizes the commission upon a request from private parties to preempt a state law that doesn't comply with Section 253C. I think
that's after notice and an opportunity for comment.
Yes.
Right?
So when we conduct those proceedings, so what What ordinarily happens is a party comes to the commission. This, I believe, is what happened in California Payphone. Came to the commission, and in that case, it was service providers saying that here are some local requirements that we believe are prohibiting us from providing service. Can you declare in an order that these are preempted? And that's an opportunity for case-by-case adjudication that occurs there. When we do that,
But,
yes.
And you issue notice and an opportunity for public comment?
Yes, any petitions that come to us, we are putting out for public comment.
I'm not following this. I live in Arizona, we have a lot of poles that look like cactus. If the city of Scottsdale were to have a requirement that all of these poles have to look like cactus, and somebody didn't like it, what would they do?
Well, so first of all, let me just say the order specifically speaks to camouflaging. I think that's the lens we look through it, and it does acknowledge that camouflaging wireless facilities imposes some burdens on carriers, but says those are permissible burdens.
How does this work? I don't understand how
So,
you get
yes.
a notice and comment on what?
So nothing in this order is self-enforcing. So what happened in that scenario, I think, is that the locality would prohibit this sort of construction from taking place. And then the carrier would have to come either to the commission or go to court, either under Section 332 for wireless facilities, provides a private right of action, or I believe every circuit to consider this has said that there are circumstances where a challenge can be brought under Section 253 under the Supremacy Clause. So any one of these specific factual disputes that arise. This order is designed to provide some clarity and narrow the scope of disputes, and we hope that's going to reduce the number of situations where parties wind up at loggerheads and disputes arise. But when there are remaining disputes, nothing about this order is self-enforcing.
So if somebody doesn't like the restrictions placed in the city of Scottsdale, they come before the commission under 253D?
Under 253D?
And then the commission has to issue notice and comment?
Yes.
On what?
On the petition. So we frequently get petitions from private parties seeking declaratory rulings on various matters. So our normal process for those is we issue a public notice putting the world on notice that these disputes are before us and seeking comment from private parties,
And it's treated as an adjudication, or is it treated as a rulemaking?
It's generally treated as an adjudication, Your Honor.
So somebody wants to build one of these, build something that looks like a tree. You have a notice and comment, public notice and comment on whether they should be able to build something that looks like a tree when there's an ordinance that says it has to look like a cactus?
Yes, Your Honor. The question, of course, would be whether that requirement it fits the terms of this order here, whether that's a reasonable aesthetic requirement. So when disputes arise, that would happen. Or, of course, I do think in most circumstances, given that the commission process is by Congress's requirement a little bit slower because we have to accept comment and solicit comment from all interested parties. It does happen when you have a narrow dispute between a particular locality and a particular carrier. Usually they will go to court, and of course Section 332 for disputes over wireless infrastructure, which is most of what we're talking about, not only provides that mechanism, it specifically directs the court to consider those on an expedited basis. And that's what's been happening all over the country for wireless siting for most of the 2 decades since Sprint telephony came out.
The commission handles it. Who does it get filed before the FCC?
Your Honor,
Particular bureau that handles this?
So I think they would likely go to the if they were wireless, we have a wireless telecommunications bureau, and if they were wireline facilities, and here the only thing that applies to those wireline facilities is the moratorium order. That would go probably to our Wireline Competition Bureau. But in any event, if these were filed with the commission, they would be routed to the appropriate staff within the commission.
Can I ask you, one of the requirements of this small cell order is that the aesthetic requirement be no more burdensome. I think that's the language. No more burdensome than those applied to other types of infrastructure deployments. How do you align that with the statute's reference to unreasonably discriminate, which sort of suggests that some amount of discrimination as compared to other infrastructure may actually be reasonable?
I think it would be no more burdensome than what applies to similarly situated infrastructure. So if there were infrastructure for a different type of utility that there was reason to think it's not similarly situated to wireless infrastructure, then I don't think they would prevail under that. But again, when those disputes arise, if the parties really can't find sufficient certainty in this order they still disagree on what the resolution of that dispute is, that's going to have to be put before some adjudicator to address it. And there's going to be someone interposed to address those case-by-case issues.
That's fair, but I guess the other side has raised this point that when you just compare the standards, the one in the small cell order as compared to the one in the statute, there is some possible misalignment, right, where it says no more burdensome, which would suggest parity, whereas the statute suggests actually there's some amount of discrimination that would be allowed.
Again, I think it is meant in the order to suggest parity among similarly situated infrastructure, which I think brings those into alignment.
What does that mean?
Well, so for instance, a problem that you have here sometimes is you have times when you have, say, cable equipment or electrical equipment, and what the record shows is that in many localities, they were imposing very burdensome requirements on wireless equipment that might be smaller and less, more unobtrusive than similar equipment you might see on a utility pole or on a pole that was being used to provide cable service, that was being used to provide electrical service, but for whatever reasons, localities were subjecting the wireless carriers to far more onerous requirements. So the non-discrimination principle here is just saying that if you are claiming that small cells need to meet some burdensome aesthetic requirements, but you're allowing other utilities to put larger, uglier, blighted infrastructure on the same poles, it's hard to think that this is a legitimate aesthetic requirement you're imposing. And sometimes these are being imposed for ulterior reasons, and sometimes it's just the fact that localities have laws that were written in the era of large macro towers, and they frequently have very burdensome requirements that were designed for those large macro towers that don't make sense when applied to small cells. And many jurisdictions, many states, have updated their laws to be able to address small cells. Part of the problem here, though, is that in many jurisdictions, you have outdated, ossified laws that don't address the type of equipment that's at issue here, and that is obstructing the deployment of desperately needed improved wireless networks.
That's clear in the order,
Your Honor, I think it's clear.
that this is really aimed at outdated structures.
Well, the order here is does not take a position on what the reasons are that localities may be having these requirements. So the order acknowledges up front many localities have taken measures to streamline the deployment of infrastructure as we move towards small cells and to 5G networks. Some haven't, and we're not trying to cast any aspersions on what the motives are. What I'm suggesting is that there may be many instances where there's not a improper motive going on here, but there's nonetheless a problem. And under Chevron here, our responsibility as an agency was to look at the record, and the record here showed there were real problems, there were real impediments in these 4 specific areas to the pressing public need to facilitate wireless deployment and have improved networks. And whatever the reasons for those are, is, I think, not relevant here. The fact of the matter is the record shows there were severe burdens being placed that were prohibiting the government and carriers from fulfilling the needs of modern communications networks nationwide.
I want to make sure you have a chance to address the fee issue.
Yes.
So the other side has raised the point, essentially, that under the FCC's approach, even a locality that has charges $1 above cost would fall prey to this order, and that wouldn't, the $1 really wouldn't effectively prohibit wireless development. How do you respond to that?
So I think there are a few different things to support that aspect of the order. One, of course, as Your Honor pointed to earlier, is this aggregation issue. And the small cell order is only about small cells. And the problem is that fees that might otherwise seem small in isolation, they're usually a few $100s, sometimes a few $1,000s, when you consider them in the aggregate, those per site fees are multiplied across the vast number of coordinated small cells you need to provide service. If you need 100 small cells to provide service in a town or just part of a city, a fee of a few $100s can quickly become tens or hundreds of thousands of dollars per year, and that might just be one city, because you also have to consider the effect if every other city were to start demanding similar fees. So Portland might think that its additional fees aren't all that much, but if every other city in Oregon were making similar demands, or every other city nationwide, this is prohibitive. And I think this brings us to...
So how did you get to 270?
Well, Your Honor...
Paragraph 79, footnote 233 is the only thing I can find, and I don't see much data there.
So, Your Honor, let me clarify, because this is another issue I think that was misrepresented here earlier. That 270 is simply a safe harbor. It's not a cap. There's no limit at 270.
So all right, so AT&T can come to the city of Los Angeles, the city of LA can say, we've got the numbers if you want to see them, but it's $400 a pole.
Yes, Your Honor, I'd point you to paragraph 32 of the order. It says, it is the standard itself, not the particular presumptive fee levels, that ultimately will govern. The safe harbor here was just recognizing that it wasn't...
How do you prevent then an auction from occurring? If AT&T gets there first and says we want all these poles and we'll pay $400 a pole, and LA says, gee, that's probably our cost, and it's not, does Verizon have a right to bring an action?
No, Your Honor, I don't think that anything would give Verizon a right to bring an action there that I can...
Does no have the right to bring an action? Because now AT&T is spending a whole lot more money in LA than above cost, and therefore they don't have money to put the 5G network in Fresno. That's the FCC's theory.
Well, if a carrier agrees to go in and pay above cost, there's nothing that precludes them from doing so. That is up to the carriers. It may be that the carriers, there may be some disagreement about what the costs are, but to avoid litigation...
So a carrier can pay above cost.
Yeah, absolutely.
So although the commission's rule treats the safe harbor for poles as fungible, if somebody thought that going down the middle of Orange Grove was better than going down Grand Avenue, which is the avenue right here, then you might end up with a bidding, with an auction between two carriers.
Well, so
as long as they agree.
I think that there's no evidence in the record here there are those sorts of capacity constraints at issue. I mean, if you go down the road and there are a series of streetlights up and down the road, and these small cells, while they have much less range than macro towers, they have a fair range. And so there's no reason to think, I think generally, that we're dealing with conditions of scarcity here. No one has suggested that. I don't think anything in the record demonstrates that. So I don't think you're in that sort of situation. But I do want to stress again, nothing in this order...
I'd still like you to get to how you got to the 270.
So, Your Honor, what I believe happened is that the commission took a look at various state small cell bills.
And it's interesting, counsel, that you just characterized it as you believe, because there isn't anything in this record that tells us what the commission did, other than look at bills that were pending in a number of states, mostly in the heartland, not on the coast.
So I want to try to answer that, but I just want to say to preface that this is just a safe harbor. And this order would have been perfectly reasonable even without any safe harbor at all.
But when you say safe harbor, what do you mean? You mean that if it's below that there's no problem with it?
So I think what the commission was doing here was recognizing that there exists a certain level of fees below which the fees are so likely to pass muster, they're so likely to be within what the actual costs are, that it wouldn't make sense to be expending resources on litigating those. So the safe harbor says that even if there might be a dispute at those low levels as to what the appropriate fees are, at that point, the localities can do them. This avoids the need for burdensome litigation in those circumstances. But nothing at all precludes localities from charging higher fees where their costs are higher.
Does the commission have an obligation to explain why it chose 270 as opposed to, let's say, 250 or 300?
Well, I do think that at that point you're in the area of paradigmatic line drawing, where agencies, I think, are at their greatest deference.
They could have chosen 200 or 400. That's significant, isn't it?
Well, Your Honor, I don't think that this was... something that we were able to calculate with mathematical precision. And there is a
Could you calculate it with mathematical approximation? I don't even see the approximation.
So what the commission did here.
The numbers that are in the bills that the commission relied on in footnote 233 are in the range of about $100. So the 270 appears, I mean, it may be generous for the cities, and maybe it was out of an abundance of caution. I'm just trying to figure out whether they just drew a number out of a hat, which might make it arbitrary and capricious. Again, it may be city favorable.
I do think it was out of an abundance of caution. I think that given what evidence was in the record, and of course we are reliant on what evidence is in the record here, there were notices of proposed rulemaking here, there was abundant comment from any number of parties.
Was there any numbers in the record other than the bills that were pending in state legislatures?
I don't think that all of those were bills necessarily pending in state legislatures. Most of those were enacted bills.
You're citing bills. I couldn't tell that they were enacted.
Well, I apologize for that, Your Honor, and I don't have the exact footnote numbers in front of me that were pointing to those. So I'm not, unfortunately, at the moment, able to direct Your Honors to them.
He said many different states' small cell bills adopt similar small fees, and I don't know whether that means that they were adopted or not adopted. I can't tell from the footnote. But that's the only evidence that you've got for the 270 is one footnote.
Your Honor, we have to go with what evidence is available in the record. And again, I'm going to point back to the fact that we could have had this order with no safe harbor whatsoever. And that would have been perfectly fine, just saying whatever the costs are, it's the cost. So even if there's some question about where that safe harbor was set, I'm not sure that could invalidate the whole order, or, could invalidate the safe harbor, which I don't think would offer any relief to the petitioners here. So I don't see any way in which you could bootstrap any questions about the safe harbor to invalidate the underlying standard here, which is say that fees can't exceed a reasonable approximation of the locality's actual costs. I mean, I think that our submission here is that when localities are demanding fees that exceed any reasonable approximation of the actual costs they have to incur, those unnecessary fees are having the effect of reducing deployment and thereby reducing service. When you increase the cost of deployment, you are going to get less service. You're making it a less attractive investment, so the Commission found carriers will do less deployment, and the reduction in wireless infrastructure means a reduction in wireless service. And I just want to point out...
We've let you go considerably over. I do want to just see if any of our colleagues have other questions for you. Thank you, Counsel.
Thank you, Your Honors.
Good morning.
Good morning, and may it please the Court. I'm Sarah Citron for the FCC in the United States, and I'm here to address claims of the APPA in Montgomery County. Turning first to the claim that government-owned utility poles are categorically immune from the reach of federal preemption, there's nothing unreasonable or novel about the Commission's determination that the statute doesn't provide that exemption, and it's for the reasons that I think the questions from the bench reflect. There's no dispute the restrictions on access to these poles can prevent the provision of service, and the petitioners haven't pointed to anything in the text of 253 or 332 that would carve these poles out. They're asking you to infer that exemption from the definition of utility in Section 224, which is expressly limited in the text of the statute to this section.
So what is the relationship, if any, between those two sections, 224 and 253?
They address different topics, Your Honor, and Section 253 and 332 require the Commission to find a prohibition in order to have anything to say about the rates, terms, and conditions of these government-owned poles, whereas 224, the separate regime for investor-owned poles, doesn't have the same requirement. And I'd like to be clear also that the Commission has not, in any previous material, the petitioners are pointing to the National Broadband Plan, for example, which is a staff-level document not binding on the Commission in any event. But at most, those materials cited reflect recognition that 224 doesn't provide this kind of authority, and that's not what the Commission has claimed here. We're operating under the preemptive authority of 253 and 332.
But does this sort of depend on how you characterize what the FCC has done here, whether it seems like it's more of a regulation under 253 or 224?
I don't think so, Your Honor. Even it would be possible to view them as mirror image regimes. I just think that 224 is a regime for investor-owned pools that the commission is not operating to pursuant here. And there's no reason, and certainly there can be no claim that 224 unambiguously reflects that kind of exemption. I think opposing counsel said it seems odd, but seems odd, of course, is not the standard. It was reasonable for the commission to recognize that the statute here does not present that kind of exemption. Turning to Montgomery County's claims, there's simply no need for the court to reach them at this point in light of the radio frequency order released in December, which is under appeal separately in this court and before the D.C. Circuit. If there are no further questions.
Who's going to address the interpretation of our decision in Sprint?
I think I'm happy to address it briefly. I'll say that our view is that the petitioners are arguing that there was a finding by this court in Sprint that there was an that the statute unambiguously forecloses the commission's interpretation of effective prohibition in this case, and that's not true. What the court did in Sprint was recognize that there had been an error before in interposing the term may prohibit. The commission concedes that there has to be an actual effective prohibition. The question before the court is, what is an effective prohibition, and nothing in Sprint forecloses the commission's reading. If there are no further questions, I'll ask that the court uphold the commission's orders.
Thank you.
Good morning, Your Honors. Joshua Turner on behalf of CTIA and the industry interveners. And I'd like to offer a couple of thoughts here. I mean, first I'd like to talk about this court's decision in Sprint, which the other side relies on heavily. Their argument is this is a Chevron Step 1 case and that this court has decided that Section 253 is unambiguous. I think that is a massive overreading of the precedent in Sprint. As co-counsel said, that case was narrowly tailored to address a specific grammatical issue that had arisen and caused all sorts of problems in various courts around the country. This court looked at it and said, we didn't mean to intend that any potential prohibition, right? It was being used to strike down zoning ordinances that gave discretion to municipalities to make decisions. And this court said, that's not what we had in mind. We didn't mean to clip the wings of discretion of all local jurisdictions. We wanted to make sure that any prohibition that was being preempted was an actual or effective prohibition. So that's the first piece. The second piece is Sprint cites California payphone, which is the standard that the FCC adopts here, right? The material inhibition standard. And so there's no doubt in my mind, and I think there's no fair reading of Sprint that says California payphone is outside the bounds of what Sprint had in mind. Excuse me, when the en banc court decided it. I'd also like to talk a little bit about access to the courthouse and access to the FCC. I know this is an issue that was troubling Your Honors. As someone who practices in this area fairly regularly, let me just say, as a practical matter, what will happen in these circumstances is if a local jurisdiction imposes a fee that is, in our view, in the carrier's view, above costs, we will either leave and not build small cell facilities, or we will try and negotiate with the local jurisdiction to come to an agreement. And if we can't, ultimately, they're the ones that hold the keys to issuing the permits and to giving us access to the rights-of-way. If they decide not to do that, decide not to allow us to build, it's our obligation to go to court and to take them to court and say, the fees that you're imposing are outside the law, right? They're preempted by Section 253.
And so what's your cause of action?
So the cause of action...
The supremacy clause, a declaratory judgment? What's
the cause of action? Yeah, for Section 332, there's a specific cause of action in the statute. Section 332C7B5. For Section 253, the way that courts have generally treated that, there was some dispute early on about whether or not there was a private cause of action in Section 253, but where the courts have landed, particularly post-Armstrong at the Supreme Court, is that it's a supremacy clause action that you bring under Ex parte Young. So you would go in and you would say, if you take this action, you're going to be violating federal law. I want an injunction against you doing that. The other point that I think is important to keep in mind.
To the city officials or the?
To the city officials, yeah.
Can you speak to the fees? Because the other side, I think, has made the argument that we can say any amount of fee, especially in the aggregate, is an effective prohibition. So what is the limiting principle on this, or are you saying there actually doesn't need to be one?
Well, I think what the commission says in the order and in its brief, it makes a very sort of trenchant observation, right? Which is that if you're charging any amount above the amount of cost recovery, if you as a local jurisdiction are charging any amount above the amount of cost recovery, what that is a pure economic barrier to entry. That amount above the amount that you're charging to recover your costs is only serving to deter people from coming in and spending money and investing in your community. And so what the FCC says here...
Is it an effective prohibition? Any fee is a deterrent to some extent? The statute says effective prohibition, so is it that?
Yes, I think it is, Your Honor. I think what the commission said here is interpreting the material inhibition standard from California payphone and looking at it in the aggregate across all jurisdictions across the country, which is something the FCC is uniquely positioned to do. These kinds of things can't come up in normal litigation. It's very difficult to make an argument of sort of national effect in an individual litigation against a particular city, because you get into all sorts of national level discovery, and then you have problems of showing, aggregate effects across the entire footprint. So the FCC is uniquely positioned to take that into account and to look at the kinds of effects that will happen if you allow all municipalities to charge more than their costs for siting wireless facilities. And that's what the commission did here, right? It looked at the Guayanilla decision from the First Circuit, which was, I think, the seminal case that sort of recognized this proposition. And it said, yes, that's right. We need to take a look at the evidence that's in the record. We need to solicit notice and comment nationally from people who are affected across the country. And we need to make a rule that encapsulates our view, our policy view, about what the right line to draw is between prohibition and cost recovery.
Thank you, Mr. Turner.
Thank you.
Could I just ask,
Sure.
what is your take on the controversy over the aesthetic regulation?
Well, Your Honor, I would tend to agree with FCC counsel that what has happened here is the FCC has laid down a fairly modest marker about what aesthetic regulation should be. And the goal of the order generally, and of the aesthetic regulation specifically, is to decrease the number of conflicts that we have that ultimately lead to litigation. Because the litigation is time-consuming and expensive and ultimately doesn't benefit anyone. And so hopefully what the FCC has done here by saying we need to have objective, easily ascertainable standards is made those standards available so that both the carriers and the municipalities can understand what the rules are in advance, and so that we don't have to end up in court.
And I take it that the justification again of avoiding litigation would be an argument in support of the 270 limitation.
Yes, Your Honor, and that's an important point too, because the kinds of cases that we're talking about here, and I've been involved in several of them, despite the expedited treatment that's directed under Section 332, they can last 3 to 5 years, and they can cost hundreds of thousands of dollars to resolve. And when you're talking about thousands and thousands of small cells being deployed across the country, it's simply not tenable to have those fights in every single circumstance. And so it's really welcome to have the FCC come in and say, at a certain amount, we're going to presume that it's okay. We don't think it makes sense to litigate over this, and everyone should be fine with $270. And in fact, our members have seen, since the order has gone into place, a tremendous increase in the number of cities that are opting into that. And a tremendous decrease in the amount of deployment costs that we're seeing nationwide. And so we think the order is working precisely as intended, although there are a lot of cities that are simply ignoring it and hoping that this appeal turns out in their favor.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Von Eaton?
Thank you. I'm going to run through a very quick list of on this. Let me start with proprietary versus regulatory. The Boston Harbor case is very clear that the Constitution does not preempt localities except when they're acting in their regulatory authority. That's the basic rule of law. And so when the FCC says no, Congress had to be specific, they're actually reversing what Boston Harbor found was the law. And it creates an enormous 10th Amendment and Fifth Amendment problem, as you can see from my illustration with the streetlights. Essentially, what they're saying is we can require you to take those streetlights and give them over to us, even if we don't want to. You'll have to respond to applications. You'll have to come up with standards. That's exactly the sort of thing that has been found, much lesser things, as in Prince, have been found to create a 10th Amendment problem. And under the doctrine of avoidance, you would have to read the law to avoid that sort of problem, which is created by this order. The second thing I'd mention is the counsel for the FCC said we're exaggerating things. So let me just go back to the moratorium example. At paragraph 145, they said that anything that prevents or suspends or the permitting process is a violation of 253A. They said it in paragraph 151. They said we're not deciding anything in particular, but if you have this, it's a violation of 253A. Okay? Now, if that's what they've said, and that's meant to have the binding power of law, it's not a case where we can come in and challenge these on a case-by-case basis. They've declared what the law is. Now, if all this was just guidance, it wouldn't be a problem. But it's not just guidance. They're purporting to speak with the authority of law. And at paragraph 153, they said there would only be rare exceptions because management does not include the right to stop construction. So we can't even come in and say there's a reason why we stopped construction because the FCC's interpreted the word management, which we don't think they have authority to do and certainly have no expertise, to mean when you're managing your rights of way, you can't stop construction for periods. So what the FCC sees as a generous order, when you look at what the findings of law are, is actually pretty harsh. And the same thing is true with the reasonable aesthetics requirements. Council says we allow reasonable aesthetic requirements. Well, reasonable is defined as technically feasible. Okay? And we know from their discussion of we know from the intervener's brief that the interveners view that as meaning they get to install what they want and basically where they want, subject to only such minor adjustments as they can make without preventing them from doing that which they want to do. So it doesn't protect the city in terms of the replacement of the streetlights, and nor does their entire structure make sense from an arbitrary and capricious standpoint. Let's take the example of it just has to look like other utilities. Well, the streetlights are another utility. And if they can't make it look like the streetlight, they still get to remove it because the way this thing is set up is they don't actually have to comply with standards that are there for other electric utilities or anyone else because they always have this technical feasibility out, right? It doesn't actually end up working the way the FCC is explaining it does. They've created too many holes in this. That's one of the reasons we're raising both Chevron 1 and Chevron 2 arguments. With respect to the fees, let me just be clear that the money they came up with comes into play in two ways. One is to create a safe harbor, but the other is it is the sole basis for finding that there's an effective prohibition. And in the order, they say, we've done the examination. We think $100 or $270, those are the right amounts. Those reflect city cost. They absolutely ignored the extensive data. And there's extensive material we submitted at LGER 366 to 459 that indicates that the cost of doing the sort of work that's required to accommodate a small cell is far greater than what they've estimated.
Okay, so can you shed any light on footnote 233? Were these bills actually enacted, or were they just pending bills?
Some of them were enacted, some of them weren't. I can't remember whether all the ones that were listed were enacted.
The fees that are listed there, Arizona, Missouri, Arkansas, Delaware, are quite a bit less than the 270 fee that the commission came up with.
That's correct. But remember, the purpose of the bills never. The commission assumes these were numbers that the communities came up with to estimate, the states came up with to estimate cost, but that's not the case. The numbers aren't supported by cost. The states didn't claim they were cost-based.
Right.
The states claim they were intended.
Presumably the states haven't undervalued. They haven't gone below the costs.
Oh, I'm sure they have, actually. I'm sure that the goal that's being sought here is to encourage deployment. I think they've made a policy choice that even if there's an additional cost.
Subsidize it.
That's correct.
Okay.
You can't assume they're not subsidizing because we actually have an example, one of the ones that.
But presumably, for example, the state of Arizona, which was going to charge, I think, $100 per pole, won't complain if they actually have to get $270 per pole.
Well, they won't be able to get that because they won't be able to go above the state law limit, but they wouldn't complain about it, no.
So
But
even with the safe harbor, that doesn't preempt the states?
No, the federal law doesn't preempt the states. So in the states that have adopted a lower level, those levels stay in place. Okay.
And what tells us that?
I'm trying to remember where it is in the order.
Or is this just simply a function of the fact that the cost can be negotiated?
It's a function of the fact that the FCC safe harbor doesn't require you to charge the safe harbor. You can charge less than the safe harbor or nothing. It's simply an amount to which you can charge that would not be subject to challenge. But if you choose to charge less, it doesn't prevent you from doing that. What it prevents you from doing is actually either doing a cost base that's basically it's the problem really is the prohibition is found based on numbers that have nothing to do with cost, and the commission ignored the data in the record that indicated that costs were actually much higher than
Any insight as to where the 270 number actually came up with?
I'm not sure where the 270 came from. I think this is one of many unexplained points in the order.
Mr. Van Eden, your
Yes.
time is up. I want to see if anyone has other questions for you, though.
May I just make one more point?
Please wrap up,
do
yeah.
keep in mind that 332 and 253 are different. And when they're talking about discrimination, 332 only prohibits discrimination against functionally equivalent providers of functionally equivalent services. So when they look at 253, they're actually ignoring the explicit limits of discrimination to 332.
Thank you very much.
Thank you.
Just want to briefly respond to a couple of things from the FCC. First of all, as my co-counsel, Mr. Van Eaton indicated, in the market participant doctrine, there is a presumption that the governmental entity can continue to act in proprietary activity. The FCC found that everything in the record showed that indeed the state and local governments were acting to pursue regulatory objectives. But that's simply not true. They did not even mention any of our comments where we specifically pointed that, at least with respect to public power utilities, they own, maintain, and manage access to their electric utility poles in a proprietary manner in exactly the same way as private other utilities and other entities with private structures within the right-of-way and outside the right-of-way. Second, I wanted to point out the fact that while the suggestion is that the FCC is not regulating these facilities by public power utilities in the same way that Section 224 does not allow, because they're simply exercising oversight. But there's nothing in this order that suggests that the scope of it doesn't apply exactly to public power utilities. In other words, the public power utilities are also subject to the rate limits, the shot clocks, the timing, the moratorium, everything under that. That looks very much like a regulatory regime being put under the cover of oversight. And then the final thing I'll talk about is the parade of horribles. The problem is that with this presumption that these government entities are somehow acting in a regulatory context and subject, therefore, to Section 253, the FCC is saying, well, you can overcome it in particular instances. But they've already put the thumb on the scale. And in fact, they've already told district courts, this is how we view this, this is how we believe you should view it, let alone how the FCC has certainly indicated they intend to view this when someone brings one of these cases to them. We believe that, if anything, then if they've put the presumption back to where it should be, if some carrier can bring a case demonstrating that it actually is causing an impediment and is actually being undertaken for regulatory purposes, then maybe you can bring that case. But they've flipped that presumption and making us overcome it. And then the final thing, while I agree that probably they're not saying there's bad motives, the FCC goes out of its way to say, we're concerned that these entities will be utilizing claims of proprietary activities as a pretext to advance regulatory agendas and objectives. There certainly is no instance of that the way that electric utilities provide access to their poles.
Thank you very much. Mr. Gotting, you have the final word.
Yes, and it will be brief. In response to opposing counsel, I would just simply ask that the court require the FCC, in the context of this order, to respond to Montgomery County's comments as well as others, and not force us into another lawsuit. Thank you.
Thank you. I want to thank, on behalf of the panel, all counsel and all parties for their help in helping us work through these important issues. I think the briefs and the arguments are a testament to the amount of care and attention you've all put into this. So on behalf of the court, we thank you. We also thank you for working productively with our court staff to help schedule all of this. Thank you again for that. So to the extent of the petitions for review challenging the moratorium and small cell orders, those matters are submitted, and we will now turn to the pole attachment issue. Mr. Langley, when you're ready.
Good morning, Your Honors. Eric Langley here for the petitioners, which are a group of investor-owned electric utilities, as distinguished from the public power utilities referenced earlier, who take issue with four particular parts of the FCC's 2018 pole attachments order. The first are the pre-existing violation rules. The second are the overlashing rules. The third is the new rule which allows self-help in the supply space. And the fourth is the new presumption relating to incumbent local exchange carrier rates. I want to start with the pre-existing violation rule, and I want to also kind of frame this, and in particular, how this issue comes up. So typically, when a new attacher wants to make an attachment, there is a survey done to determine what the condition of the existing pole is. And sometimes that survey will reveal that there is a safety, reliability, engineering, or capacity issue that either prevents access or has to be resolved prior to access. Well, the FCC's two pre-existing violation rules, which are found in 1.1411C2 and 1.1415B, both fly directly in the face of the Electric Utilities Bill of Rights within the Pole Attachments Act. And that is found in Section 224F2. Because while the Pole Attachments Act generally requires electric utilities to allow access to poles, there is a very important exception that really threads through our entire case. And that is that an electric utility may deny access on a non-discriminatory basis for reasons of insufficient capacity, safety, reliability, and generally applicable engineering purposes. And the two particular parts of the rules that I just referenced, it is specifically the last sentence of 1.1411C2 and the first sentence of 1.1415B are directly contrary to Section 224F2.
So do you agree that if your clients were to deny access based on a safety issue, it has to be a bona fide one?
Yes, absolutely. And the FCC has said in response to our argument, which is basically their argument is a straw man, they say, well, electric utilities don't have unfettered discretion to determine what a safety violation is. That's not the issue here, because this rule, the operation of this rule, begins with the presumption that there is a safety violation. And the FCC doesn't take exception to that reality. They instead try to shift the focus to this issue of discretion in determining what is and is not a legitimate safety violation. We don't deny that that's a fair issue. It's just not the issue before the court. And so I'd like to transition to the overlashing rules. And while one...
So you restate the issue that's before you go to the overlashing. So restate the issue that you think is before us.
That whether the two pre-existing violation rules in the FCC's order conflict with the plain language of Section 224F2, which is the electric utility right to deny access for reasons of safety.
Before you move on to the other issues, though, still on this one, the FCC in its brief seems to suggest, well, if the new attachment isn't creating an additional safety issue above and beyond the existing ones, that maybe that would be different. What's your response to that?
It wouldn't be different. There would still be a reason of safety, reliability, engineering, or insufficient capacity that would warrant a denial of access. The statute doesn't say anything about incremental additional violations of safety, reliability, engineering, or capacity rules. It just speaks in terms of those four things.
So is this a Chevron Step 1 issue then?
It is. This is very much a Chevron Step 1 issue.
Well, that's a huge leap, counsel, on F2. I mean, it says for reasons of safety. You've got to presume that there's some reason that adding a box to the pole is going to create a safety issue. If adding a box to the pole won't create any safety issue, what's the problem? I'm not sure that I read this as so unambiguous that it's only capable of one meaning.
Because the statute doesn't say if the new attachment creates a safety violation. It simply says that access can be denied.
It says for reasons of safety, but that doesn't mean anything we darn well please as long as we label it safety.
No, but that's the issue that the FCC is trying to frame, which I said was the straw man argument. We're not saying that we get to determine the final word on what is or is not a safety violation. So if we deny access for reasons of safety, and the attaching entity takes exception to that, there's a process that they can go through. And while the Commission has traditionally afforded significant discretion to electric utilities, they can overturn that. They can say, no, that was not a legitimate basis and you've got to allow access.
So what's puzzling me a little bit is who's supposed to fix the safety violation?
Well, that is an issue that's actually beyond the scope of our challenge. Now, the electric utility position would...
It's a question of statutory interpretation that we're talking about
here. It is. So as a practical matter, our position is that the entity that caused the violation should fix it. And sometimes that would be us, but more often than not, it's going to be one of the...
FCC says we don't have any, we can't do that. We can't go back and order that, doesn't it?
Well, but that's one of the fundamental problems with the rule. And so the FCC's justification for violating the statute is because it lacks the authority to do what it really needs to do. But that's not a legitimate basis for creating a rule that conflicts with the plain language of the Act. And if I may, I'd like to transition to the overlashing issue. So here there are two aspects of the overlashing issue that we challenge. And to be clear, overlashing is putting an additional fiber or coaxial cable or something else on the existing strand. So this is going to present a greater wind or ice loading profile on the pole line. Well, electric utilities need the opportunity to actually engineer that and to determine whether or not they have to deny access for reasons of safety, reliability, engineering, or capacity. But the FCC's new rules do two things. Number one, they cast into question whether or not the electric utility can still actually deny access for overlashing. Well, the courts and the FCC have long held that we can, but the new rule doesn't reflect that anywhere. The second problem with the rule is that it undermines the type of information that electric utilities can require with the advance notice, which would allow the electric utility to actually evaluate this from an engineering, reliability, safety, and capacity perspective. And so while we think that this is really a Chevron 1 issue insofar as it is an unreasonable interference with the Bill of Rights, that is Section 224F2, it also fails under Chevron Step 2. The third issue that I'd like to address is the new presumption relating to ILEC rates. And it's important to understand from the outset what the ILECs are. These are AT&T, Verizon. These are the old monopoly telephone companies that have wireline facilities on electric utility poles. And electric utilities have, in turn, facilities on the ILEC poles. Now, for the longest time under the Pole Attachments Act, nobody took exception to the commonly known truism that ILECs were entirely excluded from protection under the Act. In 2011, though, the FCC changed that. And they did so on the basis that there is daylight between the term provider of telecommunications service, as used in Section 224A4, the definition of pole attachment, and telecommunications carrier, as defined in Section 224A5. And the DC Circuit affirmed that distinction. And I'll go to my grave believing that the DC Circuit was wrong on that. But if they were right, and if the FCC was right, it means that Congress was intentional, not accidental, in using those two terms. And so if that was intentional, then we have to give meaning to the specific sets of rights that Congress gave to telecommunications carriers, and that they, by inference, excluded from ILECs. And chief among those is the mandatory access to poles. And the FCC takes no exception to that exclusion. But the other one there is the Section 224E rate, known as the telecom rate, which is specifically reserved for telecom carriers. Yet the FCC now has adopted a presumption that ILECs are the very thing Congress said they were not, that is, telecommunications carriers. And so here we have very much a Chevron 1 issue, assuming there's any deference to be accorded at all. And it's not clear the FCC, was actually interpreting their authority under the Act here. For all it appears, they just decided that they needed to create some sort of presumption and pulled it out of thin air without giving due consideration to the statutory constraints. And so our argument is that the FCC cannot legally adopt a presumption that two things are the same when the statute says that they are different. The last issue that we intend to raise, and I'll be brief because I do want to reserve a little bit of my time for reply, is the FCC's extension of the so-called self-help make-ready remedy into the electric supply space. The electric supply space is the top of the pole. It's where the electric lines are. It's where the stuff is that, quite literally, if you touch it, it can kill you, as distinguished from the communication space, which is generally the lowest portion of the pole. Well, in 2011, the FCC said that attaching entities could, under certain circumstances, perform self-help in the communication space. That is the place where you don't have lethal lines, but specifically said that safety concerns precluded extending that remedy into the supply space. Well, in 2018, without reconciling those safety concerns, the FCC extended that remedy into the supply space. And so the argument we're making here is not really a Chevron 1 argument so much as it is an APA argument. There was not sufficient notice and not a sufficient opportunity to develop a more specific record on something so significant as allowing third parties into the potentially lethal area on the pole. And if there are no questions, I'd like to reserve my remaining time for reply.
Thank you. Good morning.
Good morning. May it please the court. My name is James Carr. I represent the Federal Communications Commission. I'd like to start with the pre-existing violation rule that Mr. Langley was speaking about, and I'd like to give the court some context about that. Judge Schroeder asked a question about who's supposed to fix the violation. I think that's a key question, and that really was the genesis of these rules. What the commission found in the record was that certain utilities were basically saying to new attachers who proposed a new attachment, you can't get on the pole until you fix a pre-existing violation or until you pay for a repair. This was a violation for which they were not responsible, that they did not cause, and the commission thought that was unjust and unreasonable. It said so in this order, and it said from here on in, new attachers cannot be expected to pay for that, for that repair. Now, who does pay? The utility can certainly charge the pre-existing attacher who was responsible if they can locate or find the source of that. Ultimately, the utility is going to have to be responsible for caring for its poles. And the commission's point in adopting these rules was that the utility can't delay in repairing the poles just because it cannot find the source of the original violation. We make that point in paragraph 122 of the order, the final sentence of that paragraph. We also clarify a utility cannot delay completion of make-ready while the utility attempts to identify or collect from the party who should pay for correction of the pre-existing violations. The idea was that the utility has to fix it unless if it can immediately identify the source of the problem and get that attacher to fix it, fine. But there shouldn't be undue delay to the new attacher who has no responsibility for the pre-existing violation. As we pointed out in our brief, the rule in place was meant to deny utilities the ability to deny access in situations where the new attachment would not cause any additional problems. That is,
so if the utility says, with respect to pole number 103,
yes.
There's a problem with that pole, we don't want you attaching at this time. Now what?
And if the utility could say that the attachment would cause additional problems, would exacerbate the problems with it could deny access for a limited time, but it would still be responsible for fixing that pole within a reasonable period of time. If the new attachment itself would not affect the pre-existing safety violation, the attachment could go forward. That's the point of the rule. The safety issue here, it seems to me...
no harm, no foul? So.
Yes, exactly. And the safety issue here, it seems to me, the utilities are complaining about, the commission's not concerned about safety. I would ask, if there's a pre-existing violation on the pole, why are the utilities not fixing it? If it's that serious a problem, why are they saying to a new attacher, well, you can't attach until you fix it? What we were finding was these violations were going unrepaired for long periods of time. This was not for reasons of safety, we would argue. This was for reasons of cost shifting. These petitioners, or these utilities, basically wanted the new attacher to pay for the repair when they weren't responsible. And so we've ended that practice. If I could shift now to the overlashing issue. I think the first issue that these petitioners are raising is not ripe for the reasons we've described. They're basically saying they think this rule could be read to allow an overlasher access to a pole, even if there is an ongoing dispute between the parties as to whether there is a real safety or engineering issue. That comes from, there is a back and forth that is provided for in the rule where the utility can go to the overlasher and say, we think there's a problem. We think you need to modify your overlash. And at that point, the overlasher can say, okay, we will modify. Or it can say, we don't think we need to modify, and here's why. And then at that point, if there is a disagreement, the rule is vague as to what happens then. We think as a practical matter what would happen is that the two sides would sit together at a negotiating table and work it out. If there remains a dispute, in all likelihood what's going to happen is it will come to the commission. One party or the other will bring it to the commission for resolution. But in no instance would it appear that the overlasher would simply go ahead and proceed with the overlash. At least that's not mandated by the rule. And at this point, the commission simply hasn't addressed that situation. But we think in most instances this would be simply resolved through negotiations between the parties. On the point about they don't feel they're getting enough information to evaluate the overlash, the engineering studies point, I would point out that the overlashing rule is actually a codification of a pre-existing policy that has been in place for about 2 decades now. And if you go to paragraph 117 of the order, we discuss that pre-existing policy. The Commission has never required pre-approval requirements. In fact, in the earlier rule, it didn't even have a codification of advance notice, although oftentimes the parties would negotiate for advance notice. But the Commission notes at paragraph 117, pre-approval is not currently required, and the record does not demonstrate that significant safety or reliability issues have arisen from the application of the current policy. Rather, the record reflects that an advance notice requirement has been sufficient to address safety and reliability concerns, as it provides utilities with the opportunity to conduct any engineering studies or negotiation or inspections either prior to the overlash being completed or after completion. If there had been problems before this, presumably the Commission would have known about them. These parties would have put them into the record. The fact is the policy was working, and this is simply a continuation of an existing policy. I would also note that the D.C. Circuit in Southern Company approved the earlier rule, which also did not allow for pre-approval, but allowed for parties to negotiate their differences. The D.C. Circuit thought that policy would work, and it has. So now if I could turn to the ILEC rate issue. The statute, and the D.C. Circuit affirmed this interpretation, the statute does define telecommunications carrier to exclude incumbent local exchange carriers for purposes of this section. But you will notice that the term pole attachment in the statute, 224A4, means any attachment by a cable television system or provider of telecommunications services. Now, provider of telecommunications service is not defined here in the statute. Clearly, though, an incumbent local exchange carrier is a provider of telecommunications service, and therefore the Commission reasoned when the statute refers to pole attachments. And you'll note that 224B1 gives the FCC the authority to regulate the rates, terms, and conditions for pole attachments. So that covers the incumbent local exchange carriers. That's what the D.C. Circuit found in 2013 in AEP. Now, at that time, in 2011, the Commission said, we think that incumbents are different in certain important ways from other attachers, but we will give incumbents the opportunity to overcome that presumption with evidence. Over time, the Commission found a record of changing circumstances. The incumbents no longer look to have the same sort of bargaining leverage or bargaining power that the Commission thought they did back in 2011. The number of poles they own relative to the utilities has declined substantially, so they seem more like the other communications attachers. Therefore, the Commission decided to adopt a rebuttable presumption, which basically says we will treat, in complaint proceedings, we will treat incumbents just like other communications attachers unless utility can show us that these incumbents have certain material advantages in their joint use agreements with the pole owners that justify a higher rate. And we thought that the rate in place should be, or the presumptive rate should be, the rate charged under 224E, which is charged to all other telecommunications carriers at this point. We do not read E as a prohibition. We read E to require the Commission to apply that rate formula to telecommunications carriers other than incumbents. We believe, however, that when there is evidence that the telecommunications carriers are similarly situated to other carriers that receive the 224E rate, it is well within the Commission's discretion to require that those similarly situated carriers be charged the same just and reasonable rate. And that's what the ILEC rate issue is about. If I could get to the self-help issue, Mr. Langley has just discussed the one issue today, which is the notice point. I would note, first of all, that that point was raised only in a footnote in his opening brief. But if the court decides to look at the issue, we believe on the merits that the Commission has given adequate notice. If you look to paragraphs 6 and 7 and paragraphs 13 and 14 of the NPRM, they indicate that the Commission was actively seeking comment on certain reforms that envisioned that new attachers would get access to poles to do adjustments on pre-existing attachments to make ready those poles for their attachments. Various commenters on both sides of the issue actually came forward both opposed to and supporting self-help above the communication space. In our view, that only confirms that this was a logical outgrowth. The final rule was a logical outgrowth of the notice.
Are there, are there safety considerations here?
There are safety considerations, Your Honor, and we think that the Commission adequately took those into account. It's important to remember that self-help in this circumstance only comes into play when the utility fails to meet its own make-ready deadlines for work above the space. And these petitioners have not challenged the reasonableness of those deadlines or indicated that they are in any way unreasonable. Even if they're not able to meet the deadlines, they will then get 5 days' notice of the self-help remedy being employed. They could finish the work within those 5 days. Let's assume they don't finish the work and the self-help is invoked. The utilities maintain considerable control over those processes. For one thing, any contractor that is hired to do the work must be pre-approved by the utility, must be qualified. And the utility also has an opportunity to be present when the make-ready work is performed. That's important because the utility can then offer, representatives of the utility can make objections in real time if they think there's a problem, either with to the attacher or to the contractor performing the work. And the rules actually provide, I believe it's 1.1412D, which is a contractor rule in terms of interaction between contractors and utilities. The consulting representative of an electric utility may make final determinations on a non-discriminatory basis where there is insufficient capacity and for reasons of safety, reliability, generally.
So what we're doing is balancing the safety concerns and with the need to get the work done.
That's right. That's right, Your Honor. And in this particular context, you're talking about pole top attachments. These are the small cells that are used to provide 5G services. To the extent there's some suggestion that having attachments up there is unsafe, there's no basis for that because there are thousands of them now up on pole tops throughout the country. That's indicated in one of the comments that Crown Castle had, and that's in the respondent's excerpts of record at page 126, the Crown Castle comments at page 18. They talked about how Crown Castle and other companies have safely installed thousands of pole-top wireless attachments. So it's not about the attachments. This is really about the utilities not doing the work on time. They weren't doing the work on time. The earlier complaint process wasn't working because it was taking too long. These parties wanted to get their small cells mounted quickly. And one way to do that was to create a self-help remedy, which we believe will probably get the utilities' attention and actually get them to comply with the deadlines.
Thank you, Mr. Carr.
Thank you very much, Your Honors.
Morning.
Good morning, Your Honors. Claire Evans for the interveners, U.S. Telecom, and Verizon. The challenged reforms were well within the FCC's Section 224 authority. They were incremental next steps from a series of reforms that have occurred throughout several orders and been affirmed by various courts of appeals. And they were all tailored solutions, carefully designed to address specific problems that have stymied the FCC's long-standing efforts to accelerate the deployment of broadband and other advanced services at just and reasonable rates. The ILEC rate reforms were the next step in a series of orders that the Commission has passed trying to rationalize rental rates so that competing companies providing essentially the same commingled communication services using about the same amount of space on a pole would pay about the same rate. And the reason that the Commission has the responsibility to ensure that result, or at least reasonably has sought to do so, is in subsection B1 of the Act. There it says that the Commission shall regulate the rates, terms, and conditions for pole attachments to provide that such rates, terms, and conditions are just and reasonable. Pole attachments is a defined word. It is defined in A4. The term pole attachment means any attachment by a cable television system or provider of telecommunications service. And so the Commission has sought to rationalize rates such that they are not based on outdated rate disparities, but that the companies are paying about the same just and reasonable rate. The Pole Attachment Act does have rate formulas. Those formulas, as one of them is in subsection E, the other is in subsection D for cable and for telecom. And the Commission has found that ILECs should presumptively pay the telecom rate. The reason that that is entirely reasonable and appropriate follows from a line of cases as well. The Supreme Court, in fact, in Gulf Power found that the sum of transactions covered by those rate formulas is not necessarily equal to the coverage of the Act as a whole. Congress has chosen to use the term telecommunications carrier when describing one rate formula, cable when describing another. But that does not mean that the entities that do not fall in those terms are exempted from B1. B1 is the section that controls and requires the just and reasonable rates. The Eighth Circuit, just a few years ago, affirmed the Commission's decision to try to rationalize rate, found that the statute permits rates among these various providers, cable providers and telecom carriers, to diverge, but it doesn't require that they diverge. And so that the FCC's policy of seeking to rationalize rates is reasonable. The 2011 effort there was a lot of record evidence that it was stymied by the opportunistic claims of illusory or benefits that should justify a higher rate. The Commission in 2018 quite reasonably gave the electric utility the obligation to prove that those benefits exist if that utility wants to continue charging one out of several communications carriers a much higher rate for the same use of space on a utility pole.
I just ask you one question. There's been a whole kind of a revolution since the Congress passed this statute in terms of the kinds of entities we have. Are there any bills, any proposals floating around in Congress that would affect this, just out of curiosity?
Not that I'm aware that would affect this issue. This issue really goes to the language as drafted in '96 to provide all providers of telecommunications services just and reasonable rate. And the record evidence showed that by denying those rates to the ILECs, it was thwarting the Commission's goals of broadband and other deployment. And so the record evidence continued to show a significant disparity in the rates. The fact of that disparity was not rebutted by the electric utilities, who could have come forward with evidence that they had either reduced rates or had shown how rates were in parity. Instead, the only record evidence on the issue of rates indicated from carrier after carrier, ILEC after ILEC, that exceptionally large rate disparities persisted that were thwarting the Commission's goals. Thank you, Your
Thank you
Honor.
very much.
Just two quick points, one about the ILEC complaint rule, the other about pre-existing violations, and I'll start with the ILEC issue. Let's be very clear about what is and is not going on here. So in 1996, when Congress amended the act to allegedly create this provision that allowed regulation of ILEC attachment rates on electric utility poles that even the FCC didn't even realize existed for the first 15 years of the statute, it was because of the differences in these types of carriers. And they're belittling these differences, but they are significant, because the baby bells that grew up with the electric utilities, they shared each other's poles. Rather than building two redundant networks, they split the cost of a single network, agreed on a way to share those costs. And so the FCC and the interveners bemoan these changing circumstances and the shift in bargaining leverage. But that is really a foundational farce, to be frank, because if one party's bargaining leverage to be higher than the other, each has to be some value in excess of zero. And this is and always has been about existing infrastructure, the stuff that electric utilities and ILECs to some extent built under those existing joint use agreements. And neither party has the right to change the existing cost-sharing relationship within those agreements. So neither party has any bargaining leverage. So it's both parties have zero. With respect to going forward infrastructure, and this is in the record, electric utilities have always been content for ILECs to attach on similar rates, terms, and conditions to cable television systems and telecom carriers for new infrastructure, not for the stuff that was already built under the old deal. Real quick, with respect to pre-existing violations, I think Mr. Carr hit the nail on the head when he said that now the electric utility has to fix the violation. Well, that runs headfirst into the exact same error that the 11th Circuit overturned in the Southern Company v. FCC decision, albeit on insufficient capacity grounds. Because in that case, what the FCC had done is said, well, if there's an insufficient capacity problem, you need to fix it. I see my time is expiring. May I finish my sentence?
Yeah, finish your point, please. Yeah.
So the FCC had said, if there's an insufficient capacity problem, you have to fix it. The 11th Circuit said no, because the plain language of 224F2 says not. And unless there are further questions, that concludes my argument.
Thank you very much.
Thank you.
I want to again thank all counsel for the fine arguments and for the fine briefing in these very important cases. The matters are submitted, and the court will stand in recess until tomorrow morning.
All rise. This court for this session stands adjourned.